Mr. President, I come to the floor to comment on the NDAA, the bill in front of us today, and I want to just start my remarks by acknowledging the leadership of Chairman Levin, Ranking Member McCain. Under their tutelage and leadership, the committee's worked tirelessly to craft a Defense Authorization Act that provides our armed forces with the equipment, the services, the training, and the overall support that they need to keep us safe while they themselves are being protected. And I want to thank the chairman, the ranking member, my SAS colleagues, and I think most importantly the wonderful staff that work for us for their diligence and dedication to this important work. Mr. President, I also come to the floor to speak out against a proposed change that would, I think, alter what has been a very effective set of terrorist detention policies and procedures. And I believe to make those changes would complicate our capacity to prosecute the war on terror and call into question the principles that we as Americans hold dear. And, Mr. President, I filed an amendment that would, 1107, that would take a look at what is proposed in the NDAA. Now, we have a solemn obligation, Mr. President, to pass a National Defense Authorization Act, but we also have a solemn obligation to make sure that those who are fighting the war on terror have the best, most flexible, most powerful tools possible. And I have to say again, and I will say it more than two times in my remarks, that I'm worried that these changes that we're about to push through would actually hurt our national security. I'm a proud member of the Senate Armed Services Committee. And as I've implied, and I want to be explicit, I understand the importance of this bill, and I understand what it does for our military, which is why, in sum, what I'm going to propose with my amendment is that we pass the NDAA without these troubling new provisions, but with a mechanism by which we can consider what's been proposed and perhaps at a later date include any applicable changes in the law. But we need to hear from the Department of Defense, our intelligence community, and the administration more broadly on what our men and women in the field actually need to effectively prosecute the war on terror, especially before we change detainee policies that are already working. Mr. President, as I'm saying, I've got really serious concerns about the detainee provisions that have been included in the bill. In my opinion and the opinion of many others, and I will share those opinions and insights with my colleagues, these provisions disrupt the executive branch's capacity to enforce the law and impose unwise and unwarranted restrictions on our ability to aggressively combat international terrorism. And in so doing, they inject legal uncertainty and ambiguity that may only complicate the military's operations and detention practices. And, Mr. President, I'm not the only one that has serious concerns. The Secretary of Defense has urged us to oppose these new provisions. Both the chairman of the Intelligence and Judiciary Committees strongly oppose them, and the President's team is recommending a veto. These are people whose opinions should be carefully considered before we put these new proposals into our legal framework. In the Statement of Administrative Policy, the White House states, quote, "We have spent 10 years since September 11, 2001 breaking down the walls between intelligence, military, and law enforcement professionals. Congress should not now rebuild those walls and unnecessarily make the job of preventing terrorist attacks more difficult." End of quote. Those are striking words, Mr. President, that should give us all pause as we face seems to me, a bit of a rush to cement these untested and legally controversial restrictions on our ability to prosecute terrorists. And, Mr. President, I would ask unanimous consent to replace the entire Statement of Administrative Policy in the record.
Without objection.
These are complex issues that have far-reaching consequences for our military, our civilian law enforcement agencies, and our intelligence community as they work to keep Americans safe from harm. Despite this fact, the Department of Defense and the national security staff as far as I know, had little opportunity to review or comment on the final language in the provisions. And as a result, these provisions restrain the executive branch's options to utilize in a swift and flexible fashion all the counterterrorism tools that are now legally available. That quote comes directly from a letter addressed to the Armed Services Committee from Secretary Panetta. And I think we all know that Mr. Panetta was also, before he held the job that he has now, Secretary of Defense, he was the director of the CIA. So he very well knows the threats facing our country, and he knows that we cannot afford to make mistakes when it comes to keeping our citizens safe. And, Mr. President, I'd ask unanimous consent that Secretary Panetta's letter be entered into the record.
Without objection.
The provisions I'm speaking to are well-intended. I had much admiration for my colleagues who proposed them, but I think we need to take some more time to consider the ramifications. The United States, our country, can currently choose from several options when prosecuting terrorists. That flexibility has allowed us to try, convict, and imprison hundreds of terrorists. And it allows the government to select the venue that will provide the highest likelihood of obtaining a conviction. The current detention provisions in the bill we are debating would strip away that flexibility and potentially impair our capacity to successfully prosecute and convict terrorists. It's not clear to me why, after 10 years of successfully prosecuting terrorists and preventing another 9/11-like attack, why we would want to limit our options while our enemies are constantly adapting their tactics and expanding their efforts to do us harm. In a recent op-ed in the Chicago Times, a bipartisan group of 3 former federal judges, including William S. Sessions, who was also the appointed director of the FBI under President Reagan, said it best when describing these provisions. Quote, "Legislation now making its way through Congress would seek to over-militarize America's counterterrorism efforts, effectively making the U.S. military the judge, jury, and jailer of terrorism suspects to the exclusion of the FBI and local and state law enforcement agencies. As former federal judges, we find this prospect deeply disturbing. Not only would such an effort ignore 200 years of legal precedent, it would fly in the face of common sense." End of quote. And, Mr. President, I would ask unanimous consent that that op-ed be entered into the record.
Without objection.
Mr. President, I would also point out that these provisions also raise serious questions as to who we are as a society and what our Constitution seeks to protect. One section of these provisions, Section 1031, could be interpreted as allowing the military to capture and indefinitely detain American citizens on U.S. soil. Section 1031 essentially repeals the Posse Comitatus Act of 1873 by authorizing the military to perform law enforcement functions on American soil. That alone should alarm my colleagues on both sides of the aisle. But there are other problems with these provisions that must be resolved. These detaining provisions are unnecessary, counterproductive, and potentially harmful to our counterterrorism efforts. And, Mr. President, I know I've said this a couple of times already, but it feels like they're being rushed through in a manner that doesn't serve us well. The Department of Defense has had little input. There have been no hearings. And earlier this week, the changes were presented to us in the Armed Services Committee just hours before we were asked to vote on them. These are just too important a set of questions to let them pass without a thorough review and far greater understanding of their effect on our national security and our fight against terrorism. It feels to me, to this senator, that we're rushing hastily to address a solution in search of a problem. And we ought to hear from the Department of Defense, the intelligence community, and our colleagues in other relevant committees before we act. Do we really believe that this Congress, again, let me underline, after 10 years of successfully prosecuting the war on terror, should substitute its views for that of our defense, intelligence, and homeland security leadership without careful analysis. Mr. President, I recently received a letter signed by 18 retired military leaders in opposition to these provisions. The letter states that, quote, mandating military custody would undermine legitimate law enforcement and intelligence operations crucial to our security at home and abroad. Mr. President, I couldn't agree more. And I'd ask unanimous consent that this letter be included in the record.
Without objection.
We are already trying and convicting terrorists in both civilian courts and under military commissions. The provisions that are in this bill would require the DoD to shift significant resources away from their mission to act on all the fronts all over the world, and they would become a police force and jailers. This is not what they're good at. This is not what we want them to do, and I think it has dangerous, potentially dangerous consequences because we have limited resources, limited manpower. We wouldn't lose anything by taking a little bit more time to discuss and debate these provisions. But we could do real harm to our national security by allowing this language, unscrutinized, to pass, and that's precisely what our highest-ranking national security officers are warning us against doing. Now, this is a debate we need to have. It's a healthy debate, but we ought to be armed with all of the facts and expertise before we move forward. The least we can do is take our time, be diligent, and hear from those who will be affected by these new limitations on our ability to prosecute terrorists. And it concerns me, Mr. President, that we would tell our national security leadership, a bipartisan national security leadership, by the way, that we wouldn't listen to them and that Congress knows better than they do. It doesn't strike me that that's the best way to secure and protect the American people. So, Mr. President, that's why I have filed Amendment 1107. I think it's a common-sense alternative that will protect our constitutional principles and beliefs while also allowing us to keep our nation safe. The amendment has a clear aim to ensure that we follow a thorough process and hear all views before rushing forward with new laws that could be harmful to our national security. Mr. President, what's in the amendment? It's straightforward. Specifically, the amendment would require that our defense, intelligence, and law enforcement agencies report to Congress with recommendations for any additional authorities or flexibility that they need in order to detain and prosecute terrorists. In other words, let's not put the horse before the cart or fix something that isn't broken. Let's first hear from the stakeholders as to what laws they believe need to be changed to give them better tools to do their jobs. My amendment would then ask for hearings to be held so we can fully understand the views of respected national security experts. And moreover, it would require input from each of the relevant committees to ensure that we have carefully considered the benefits and consequences of our actions. The chairman of our Judiciary and Intelligence Committees have deep concerns about the detainee provisions in the pending legislation. And of course, Mr. President, as we underwent this process, the existing laws that guide our actions today would remain in place. They've been successful. I see some of my colleagues who I think share my views who've come to the floor. They've also made the compelling case that it's a system that's working. Why would we change it without really thinking it through? It's straightforward, it's common sense, and it allows us to make sure we will win the war on terror.
Would the senator from Colorado yield for a question through the chair?
Yes.
I thank the senator from Colorado for his strong statement, and I totally support his position. This change in the Defense Authorization Bill goes beyond a military decision. It goes to the fundamental questions and principles of our Constitution and our body of law. As a member of the Senate Judiciary Committee, I believe this matter should have been considered as well by the Senate Judiciary Committee, and I believe Senator Feinstein has expressed the feeling that it should have been considered as well by the Senate Intelligence Committee. But I would like to ask the senator from Colorado one very specific example, use one example to ask him a question. When we had the so-called underwear bomber the passenger on a commercial aircraft who tried to detonate a bomb and thank God was unsuccessful. He was subdued, arrested, and interrogated by the Federal Bureau of Investigations in Detroit. After that investigation was underway and he surrendered some information, he stopped talking, at which point the FBI investigators read him his Miranda rights. Then later, working with his parents, he resumed talking to the investigators and literally, according to the FBI, gave a dramatic amount of information helpful to us in keeping America safe and stopping terrorism. He was then prosecuted in the criminal courts of America, Article III courts, and ultimately just weeks ago pled guilty.
Senator, state his question.
I'm going to. I would say to the senator from Arizona, I think it's important we take some time on this important issue. And I'm glad the senator from Colorado has.
And I would say it's important that all voices be heard.
Senator from McCain, of course, as the ranking member, will have ample opportunity to express his point of view. What I'm asking the senator from Colorado is this: taking into consideration the language that is now being presented in this defense authorization bill, particularly Section 1032, it is my understanding that the Federal Bureau of Investigations could not have continued their interrogation of this suspected terrorist without first contacting our military and bringing them in to determine whether or not they had jurisdiction over this matter. In other words, time would have been lost, opportunities would have been lost, information might have been lost by following the new section in the bill. I'm asking the senator from Colorado if this is a decision which he believes we should make in the haste of a defense authorization bill, or ought to step back and work with the President of the United States, the FBI, the military, and our intelligence forces to make sure we do not lose an opportunity to catch a terrorist and catch an alleged terrorist, to interrogate them, and to keep this country safe.
I thank the senator from Illinois for his question. My understanding is the senator from Illinois is correct, that 1032, provision 1032, would change the way in which interrogations would unfold. Now, there may be some in the Senate who see it differently, but that's all the more reason to adopt my amendment, which would put us through a process of hearing from the very experts who interrogated the underwear bomber, of other experts who've been on the front lines in fighting terrorism. We ought to go slow. We shouldn't fix something that is working just fine right now. So I thank the senator for his question.
If the senator from Arizona will forgive me, I'd like to ask one more question through the chair. And the question goes back to the point that you made. Section 1031, as I understand it, would be a departure from current law and would say that those who are not American citizens, those who are American citizens can be detained indefinitely if they are suspected of certain terrorist conduct. I asked the senator from Colorado, is that the point that you made in your statement?
The senator from Illinois is correct. 1031 would do just that, and it would come directly at a piece of law, posse comitatus, which dates back to the Civil War, that's held dear by all of us in America because it distinguishes between the military used to protect us against foreign foes and how we manage our own civil affairs here at home.
Thank you,
it also, as the senator alludes to, I think cause questions to be raised about something that's very sacred in our system of law, which is the writ of habeas corpus. You have to prove why you hold somebody. You cannot detain an American citizen indefinitely in any other circumstance. So I thank the senator from his questions. I would yield the floor.
Would the senator yield for a question?
I'd be happy to yield for a question.
We explicitly wrote into this bill the following language: that the procedures providing for the determination that somebody is an al-Qaeda terrorist or related affiliated one is not required to be implemented until after the conclusion of the interrogation session, which is ongoing at the time the determination is made. Is the senator familiar with that language, which explicitly says that the president will adopt the procedures, whatever procedures the president determines, to make sure that there is no interference with an ongoing interrogation by the civilians, as it appears in Section C, 2C on page 363. Is the senator familiar with that?
I'm familiar with the language in the general way in which it's been introduced. I would say to the chairman of the Armed Services Committee that we had a chance to review this language starting about 48 hours ago. But one of the reasons I think my amendment is important is it would give those voices which are being heard more and more as of today who have concerns with this provision. They're not sure how it applies. That's all the more reason to slow this down, to keep the existing law in place, and go through a more thorough process to understand what the ramifications of the waiver provision and other provisions that the chairman and the ranking member.
Well, is it not true, however, that the language which is in this bill, which I've just read, clearly provides that there will not be any interference with an interrogation session, that those procedures are to be determined by the president, and that it explicitly says there will not be any interference with interrogation, and the procedures will guarantee that there will not be. That's the point of this language. I don't understand how the statement can be made that this language in this bill interferes with the interrogation by civilian authorities and the FBI when the very language here says they will not interfere with that interrogation. I'm wondering if the senator could explain to me his agreement with the senator from Illinois that something in this bill would result in an interference with an interrogation.
What I say to my friend is that having just had an opportunity to review this language for the last 48 hours, that I have no question about his intent, but I have heard from people with much greater expertise than I have that there are questions that are still unanswered. It may be that this provision is appropriate and will do just what the chairman says it will do, but I think, again, that's why I think it would be well worth our time to take a further look at what is involved in these provisions.
Well, and I do appreciate the senator's response to that. I have just one other question, and that has to do with somebody, an American citizen that is captured in the United States, and the application of the custody pending a presidential waiver to such a person. I'm wondering whether the senator is familiar with the fact that the language which precluded the application of Section 1031 to American citizens was in the bill that we originally approved in the Armed Services Committee, and the administration asked us to remove the language which says that U.S. citizens and lawful residents would not be subject to this section. Is the senator familiar with the fact that it was the administration that asked us to remove the very language which we had in the bill which passed the committee, and that we removed it at the request of the administration that would have said that this determination would not apply to U.S. citizens and lawful residents? I'm just wondering, is the senator familiar with the fact that it was the administration which asked us to remove the very language, the absence of which is now objected to by the senator from Illinois?
I'm familiar now because the senator from Michigan has shared that fact with me. I'm also familiar with the fact that the administration has other questions and concerns, which has caused it to issue a set of provisions and issues that they would like further considered.
I thank my friend.
Thank you. I'd be happy to yield to my friend from Vermont.
Is the senator from Colorado aware that there have been questions raised by the administration, some real concerns by both DOD and the White House, saying that requiring the president to devise the kind of procedures just been discussed creates all kinds of problems, and that is one of the reasons why both the Senate Intelligence Committee and the Senate Judiciary Committee is asked to at least have a hearing on a section that obviously involves the jurisdiction of both Senate Intelligence and Senate Judiciary.
I am. The senator from Vermont is correct, and that knowledge on my part is in part one of the reasons I've introduced, or filed, I should say, the amendment that we're discussing right now.
I thank the senator.
I thank the senator.